The evidence I shall table in Parliament today requires a thorough response from Government and, if necessary, this Parliament. These documents point to one of the state's largest land users systemically bypassing the state's laws to achieve quick and convenient outcomes. The company I am referring to is the Fortescue Metals Group, commonly referred to as FMG. I now turn to the facts at hand. In 2008, FMG received a report from a reputable firm of archaeologists confirming that 4 Aboriginal sites of importance and significance were recorded on exploration tenement E471373. FMG was advised that the 4 sites were protected by the Aboriginal Heritage Act 1972, and that 2 of the 4 sites were proposed as sites that should be preserved because of their potential cultural importance to the state of Western Australia. The archaeologists recommended that if FMG wanted to use the land, it would be required to seek consent of the Minister for Aboriginal Affairs. All 4 sites were described as being of cultural significance to the Eastern Guruma. This is not surprising, as they are located within 100 metres of the Duck Creek Rock Art site, which contains over 500 petroglyphs, including ceremonial and sacred sites. On or about April 2017, in preparation for the construction of the Eliwana Railway, FMG installed an access track through E471373 to facilitate access to carry out hydro-bore testing. The proposed track intersected 1 or more of the 4 sites recorded in 2008. Rather than seeking consent from the Minister of Aboriginal Affairs by way of a Section 18 application and consulting the native title holders consistent with the expert recommendations, FMG unilaterally decided that the 4 sites were not sites protected by the Aboriginal Heritage Act. We know this because between the 1st and the 13th of March 2017, FMG made a determination that, contrary to the expert findings, these 4 sites could be impacted without consent of the Minister under Section 18 of the Aboriginal Heritage Act. FMG made this determination without any discussion with the government regulator, the traditional owners, or the author of the archaeological recommendations. As members would be aware, determining what Aboriginal sites and places can and cannot be protected by the Aboriginal Heritage Act laws in WA is a statutory function reserved for the Minister of Aboriginal Affairs Expert Committee, the Aboriginal Cultural Materials Committee. However, it was FMG that performed the site assessment and not the ACMC. The tabled documents show that rather than referring the matter to the ACMC, FMG routinely conducts internal risk-based assessment about Aboriginal sites. This approach is contrary to the requirements of the legislation. FMG does not have a discretion when it complies, whether it complies with the law, nor does it have a discretion to carry out the functions of the ACMC. This is all quite extraordinary. This apparent modification of process is made worse by FMG devising a system of permits issued by its own heritage manager as authority to destroy sites. These cultural salvage permits authorised FMG staff to salvage Aboriginal cultural material objects before ground disturbing activity commences. FMG has set up a decision-making body and process within its own organisation to make decisions about sites that are reserved in law for the Minister on behalf of the community of Western Australia. On the 13th of March 2017, FMG issued a heritage work instruction to the Aboriginal Corporation to carry out an Aboriginal heritage survey and participate in the salvage of cultural material of these same 4 Aboriginal sites. I'm advised by the Corporation that they had participated in cultural material salvage exercises with mining companies before, and reasonably assumed that FMG had the necessary statutory approvals in place. It did not occur to them to question FMG about whether it had the requisite legal approvals in place. On the 10th of March 2017, just a few days earlier, FMG had submitted a program of work, a POW application seeking approval from the Departments of Mines, Industry, Regulation and Safety to install an access track on E471373, where the 4 sites were located. Officers are authorised to approve a POW application if the activity will not cause environmental impacts, including impacts on Aboriginal heritage sites. FMG did not disclose the 4 sites in the POW application, even though the sites were material to the Department's assessment of the application and its ultimate decision, which is to approve it. Had the sites been disclosed, the application would have been decided very differently, requiring FMG to seek a Section 18 consent to avoid the Aboriginal sites. There is a further example of FMG not disclosing known Aboriginal sites in a program of work application. On the 13th of August 2018, FMG made a POW application knowing that the proposed work would impact on an Aboriginal site of immense significance. The Department of Mines, Industry and Regulation and Safety has suspended its assessments since becoming aware of FMG's non-disclosure. I have other examples of non-compliance with government process. On the 30th of November 2017, the Minister for Aboriginal Affairs granted a Section 18 for Spear Hill area to FMG subject to a condition that they invite traditional owners to salvage their ancient cultural material. I'm advised that FMG have proceeded with their heavy earthworks in the area in the last 2 months without making such an invitation, and in doing so breached its legal consent. Finally, I note that the documents indicate that FMG continues to mandate its instructions to heritage consultants undertaking heritage surveys on country the use of guidance thrown out by the Supreme Court of WA and by the ACMC and the previous minister in April 2015. The Supreme Court, in the case of Robinson versus Fielding, found the guidelines to be inconsistent with the legislation. The documents I am seeking to table point to FMG having designed a system that has the effect of bypassing state law. This system includes the use of guidelines that incorrectly interpret the statute, a site assessment function that usurps the statutory functions of the ACMC and the Minister, the use of cultural salvage permits that act to substitute a bona fide regulatory authority of the Minister, misleading at least one of the Aboriginal organisation that cultural salvage was sanctioned by the Minister, withholding material facts from POW applications with the Mines Department, and ignoring the Section 18 conditions imposed by the Minister. In my view, it is imperative that the Department of Planning, Lands and Heritage and the Department of Mines, Industry and Regulation and the Safety undertake a thorough joint investigation to determine the scale of FMG's compliance failure. For example, how many sites have been assessed by FMG as not sites and subsequently impacted without regulatory approval? How many POW approvals has FMG secured through non-disclosure of material information? And maintaining the community's confidence in our system of law and public policy requires the Minister for Aboriginal Affairs and Mining to use respective authorities and hold FMG to account. And I seek leave to table a series of documents which will identify what I have just identified in my speech. There are 2 maps in those documents which are really important. One shows the sites that are defined as requiring assessment under 5B of the Act, and the second map which shows those very same sites as having been removed. Thank you.